This is the first in a series of webinars looking at law and medical practice. And today we're looking at consent or informed consent to treatment. And the reason we've chosen this subject is that cases alleging lack of consent make up the vast majority of the cases we see. Next slide, please. A bit of housekeeping. This session will be recorded and will be available to you afterwards. If you'd like to ask a question, you can do that in the Q&A box. We may not have time for all questions today, given the limited time we have, but you can contact me directly with any questions you have or subsequently think of. The next slide, agenda. We'll look first at what consent means in the context of medical practice, and then at what good practice looks like. And finally, I'll share a couple of warnings about the impact of consent on indemnity cover. As a starter though, why seek consent to treatment? The answer is simple. Consent renders lawful what would otherwise be unlawful. Touching a person without their consent constitutes a battery. That's a criminal act, even if no damage is done. Equally, in the civil law, touching a person without their consent is a trespass to the person. So consent is important. Next slide, please. The leading case in this area remains the Supreme Court decision in 2015, that of Montgomery and Lanarkshire Health Board. The claim related to the delivery of a baby in October 1998, during which a complication arose which delayed the delivery and resulted in oxygen deprivation. The baby boy was born with cerebral palsy. Antenatally, the risk of the complication occurring had been assessed at around 9 or 10%, as the mother was diabetic. The doctors didn't discuss the risk of the complication with the mother or counsel her in relation to the option of a planned caesarean section. And the reason for that was that the risk of serious injury from that particular complication was small. And if Miss Montgomery had been advised or warned about it, it was thought she would have elected to have a caesarean. And that was not, in the opinion of the doctors, thought to be in her best interests. Natalie Montgomery successfully argued that she should have been warned of the risks and given the alternative of having a baby delivered by elective caesarean section, which, it was accepted, would have resulted in the baby being delivered unharmed. That case, decided in 2015, didn't change the law. What it did was restate what the law had always been. So when looking at the issue of consent to treatment, the court said this. The next slide, please. The doctor is under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatment. The doctor's advisory role involves dialogue, the aim of which is to ensure that a patient understands the seriousness of her condition and the anticipated benefits and risks of the proposed treatment and any reasonable alternatives, so that she's then in a position to make an informed decision. This role will only be performed if the information provided is comprehensible. There are 3 particular points to take from this case. The first is that we're dealing with the patient as an individual and what that individual patient considers material. The test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. As the courts have said, next slide please. Patients are now widely regarded as persons holding rights rather than as the passive recipients of the care of the medical profession. Gone are the days when it was thought that on becoming pregnant, a woman lost not only her capacity, but also her right to act as a genuinely autonomous human being. The courts have also noted the GMC guidance from time to time when looking at the significance of a risk. And what the GMC have said is that the significance of a given risk is likely to reflect a variety of factors besides its magnitude. For example, the nature of the risk, the effect which its occurrence would have on the life of the patient, the importance of the patient, the importance to the patient of the benefits sought to be achieved by the treatment, the alternatives available, and the risks involved in those alternatives. The assessment is therefore fact sensitive and also sensitive to the characteristics of the patient. Next slide, please. The second point is that the judgment also sets out the importance of a dialogue between doctor and patient as part of the doctor's advisory role. That role will only be performed effectively if the information provided is comprehensible. The doctor's duty isn't fulfilled, the court has said, by bombarding the patient with technical information which the patient cannot reasonably be expected to grasp. Nor is that duty fulfilled by routinely demanding a patient's signature on a consent form. The third and final point is that it's clear that the Bolam principle, which decided that a doctor wasn't negligent if he or she acted in accordance with a practice accepted as proper by a responsible body of medical practitioners skilled in that particular art, is no longer appropriate. We'll look at the Bolam principle in a later webinar, but for now, in the context of consent, the issue is not whether a reasonable body of medical opinion would have been deflected from a particular course, but what advice should properly have been given to the patient and what would have happened as a consequence. Are there exceptions? There is a limited exception to what can now be considered the rule in Montgomery, when a doctor may withhold from the patient information about a risk if they reasonably consider its disclosure would be seriously detrimental to the patient's health. The courts have stressed that this exception should not be used to interfere with the autonomy of a patient where the doctor fears that the patient will make an unwise choice. Another point to note, though not an exception, but an area we often come across, is whether a doctor can be criticized for not exploring treatment options which the doctor considers inappropriate. In the case of Mukhtar Malik and St George's University Hospital's NHS Foundation Trust, which was a case before the High Court in July this year, this was the point in issue. The case involved spinal nerve decompression surgery and left the claimant with incomplete paraparesis, confining him to a wheelchair for most of his life. The claimant's case was that alternative treatment options were not put to him and should have been. The judge referred to Montgomery, stating that there is a duty on doctors to take reasonable care to ensure a patient is aware of any reasonable alternative treatments. But in this case, the judge found that a responsible, competent, and respectable body of skilled spinal surgeons would have reasonably concluded that there were no reasonable alternative treatments available in the context of this case, and the claimant's case was dismissed. Having looked at what consent means, what does good practice around consent look like? Next slide, please. The first 3 points on this slide follow naturally and logically from the case law we've just looked at. The final 3 points are what lawyers will always advise, because it's only if you can prove that consent was obtained that you can successfully defeat an allegation that it wasn't. Although consent forms are usually routinely used, the taking of consent is more normally a process rather than an event. Many clinics or surgeons will have information on their websites or in leaflets about treatment options. They'll often identify a broad range of risks, and many comprise lists of frequently asked questions and answers. But as the case law makes clear, the material risks for a particular patient at a particular point in time are what is important. Refer to them specifically. Record the information provided to the patient. Seek the patient's acknowledgement that they have seen relevant information. Record what, if any, questions they had about the information disclosed. Most importantly, follow up the advice provided in writing. So often, I see letters from a consultant to a GP about a patient. These can be detailed, but they can also be brief, and far too brief, on the issue of consent. If a client comes to me, I write to them with my advice. I don't write to their GP. Yet too often, letters that ought to have gone to the patient, or at least be copied to the patient, with key information, are not. Next slide, please. Finally, I wanted to refer to a couple of policy points. On this slide is a facsimile of a proposal form. The proposal form is the document a doctor will complete when they apply for commercial professional indemnity insurance. Once this document is complete, the doctor will sign and date the form and declare the truthfulness of the content. Note the questions about consent. If it becomes clear that the response to these questions was misleading, then indemnity under the policy may be in jeopardy. I know a number of surgeons who've produced their own consent protocol and documents to act as a guide or flowchart or reminder on good practice about the nature of consent and to ensure that evidence of the process is comprehensive. That step has often come on the back of a claim made against them about consent being lacking. So it's clear that issues around consent arise on an application for indemnity insurance. The reason for that is that the underwriter, the insurer, knows, as I do, that cases involving alleged lack of consent are on the increase. Accordingly, they want to know how good or poor an insurance risk a doctor might be, hence the questions. Once insurance is in place, it's common to find that it's a condition of indemnity being granted that full descriptive records are kept by the doctor. So again, there's a contractual requirement to keep good records, including records of the consent process. Not keeping any or any adequate records could jeopardize indemnity cover. Next slide, please. In conclusion, we've looked at why consent is required and what the key features of consent are. In summary, we're dealing with a patient as an individual and what material information is for them at a particular point in time. We know that for the doctor to fulfill their role as advisor, there should be a dialogue with the patient about the options for treatment. In future webinars, we'll look at other legal principles around breach of duty and causation and their relevance to medical practice. But for now, thank you for joining us. And I think we've got time for a couple of questions.
Thank you, Stephen. Yes, I think we've got time for a couple of questions. Here is one. If a claimant proves they did not give consent, is the doctor liable?
Good question. Not always is the answer. As well as proving that consent wasn't given, a claimant must prove that they've suffered some injury or loss. Often the claimant's case fails because even though they say they didn't consent to the treatment they received, they can't prove that they would have acted differently. Or put another way, they can't prove that their injury or loss is caused by the lack of consent. In the case I referred to earlier, the case of Mukhtar Malik against St. George's, both on the consent issue and on causation, the case failed. The judge having found that even if he'd proven that he didn't consent, he wouldn't have been able to prove that he would have acted any differently.
Okay, and just one more. What about post-treatment discussions? You talked about the obligation to get informed consent as an ongoing duty. What about post-treatment decisions?
That also is a very good question. This arises a lot, and a particular case I'm recalling involves the administration of an anticoagulant post-operatively, or to be precise, a change in the type of anticoagulant and the amount being administered. Those decisions were taken by the medical team, the doctor, without the involvement of the patient, and there were consequences of that. Now that we have a claim, with the assistance of some independent expert advice, we've had to advise that the surgeon is vulnerable on that consent issue. The rule to bear in mind is that, save in the extreme emergency case, it's the patient who makes their choice about what treatment to have or not to have, and the role of the doctor is to advise.
Okay, there are a couple more questions, but we will try and answer them remotely because I think time is up. With that, I'll hand back to you, Stephen.
Okay, well, thank you for joining us. We have another webinar coming up on the 14th of October. The presenters on that occasion will be Andrew Tobin and Peter Wedge. Andrew Tobin is a partner at Mills and Reeve. Peter Wedge is Reinsurance Counsel at Swiss Re, and the subject of that webinar will be Political Violence and Insurance Part 2, and it follows on from Andrew Tobin's introduction to political violence and insurance earlier in the year. And what they're going to look at are the meaning of common perils such as war, civil war, insurrection, usurped power, riots, and others. and they'll have a look at causation and the reverse burden of proof. But for now, thank you very much for joining us and have a good day.